And now we are down to People of the State of Michigan versus David Thompson, file 24-35559FH.
Yep. David and Houghton, appearing on behalf of the AG's office.
Mr. Thompson is representing himself, and I'm advisory counsel in this matter, but I can advise the court there is no other agreement.
All right, so Mr. Thompson is now here, making his way to the defense table.
Yes. Oh, sorry.
Just call me David, you're on.
All right, well, all right, so we are currently set, so you can have a seat. Just as you may have heard me say earlier, don't take any thought. I have nothing to know about the case. I'm just going to tell you that, as I do to anyone here for a final pre-trial conference. Today is the last date in which to enter a plea pursuant to any pre-trial agreement. Any plea from here on out must be done by entering a plea as charged. The reason I do that isn't to punish the defendant, isn't to punish anybody or encourage a case to go in any one direction. It's just to encourage you all to exhaust any negotiating that you've got to do, because everybody's got to issue subpoenas. Subpoenas have to be served by police officers or process servers. My staff has to issue jury notices. 60 different jurors have to reschedule dates and times and take off work, and employers have to do the same thing. So again, there's no punishment. It's just to make sure that we have exhausted all of our negotiating skills. So we have no resolution. The case is currently set for a trial right now. I know we have two trials set for February 18th. Excuse me, this one is set for 1 day. The other one was set for 2 days.
And I was going to, on behalf of the AG's office, I think that they're planning on it, ask that perhaps we keep both of those on. The idea being that we'll be able to conduct both of those trials in that 2-day time frame.
And was there a jury demand, I assume?
There was, your
Right.
This isn't just a routine pretrial conference. This is a textbook example of what happens when a defendant walks into court convinced that secret constitutional loopholes, imaginary legal theories, and self-representation will somehow overpower real statutes, real judges, and very real consequences. David Thompson has been on this court's radar for months, and as you're about to see, he's approaching a jury trial while carrying some of the most common and most dangerous sovereign citizen misconceptions. He believes equity can magically resolve criminal charges. He believes constitutional language overrides procedure. And most importantly, he believes he can out-argue a system that operates on rules he refuses to recognize. What makes this case especially tense is that the judge isn't hostile, isn't emotional, and isn't trying to trap him. The court is calm, patient, and crystal clear. And that's what makes every mistake David makes here so much more revealing. Pay close attention, because everything said in this hearing sets the stage for what could go very wrong at trial.
I'm going to move this to start on February 19th. So that way we have the 1 day to do the other file and the second day to do this case. So I'll issue jury letters to 4 sets, 4 panels, 2 for each day. So Mr. Thompson, that means that even though your notices say that our trial was to begin on the 18th, we're going to begin it on the 19th. We do jury selection in the morning. I need to remind you that your choice to represent yourself, you're making that on your own. Is that correct?
That's correct.
You understand the court can appoint an attorney to assist you?
Yes,
Yep.
is.
I know. Yeah, I know he's helping you,
Yes.
but you understand that he's not really representing you. Like, in other words, he's not doing the cross exam, direct exam.
That is correct.
All right. And you understand that while it might seem illogical, I have to, by law, require you to follow the same rules in the courtroom. Okay. So if you need to enter a piece of evidence into, an exhibit into evidence, you're asking questions, you're going to have to follow the same rules. Okay. And just make sure you say yes.
Yes.
Thank
yes.
you. Every person has a right constitutionally to due process, and every person also has the right to represent themselves. And again, I also just needed to make sure today that you are making this choice to continue without counsel. In other words, representing yourself. on your own. Is that right?
That is correct, yes.
And the key issue when I say on your own, no one's forcing you, no one's pressuring you. It's your choice.
They are not.
Okay, copy that.
May I?
Yes, sir.
It's my understanding, Your Honor, that there's a conflict of variance in the law, equity should prevail. I'm prepared to wrap this up and settle all of this. I've done here in this venue that's exclusive of Article 3.
I
Constitutionally speaking.
Yeah.
This moment right here is critical, and a lot of viewers underestimate just how important it is. The judge isn't just going through routine questions. This is the court building a record. Every time the judge confirms that Mr. Thompson understands his rights, understands the rules, and is choosing to represent himself voluntarily, that's another layer of protection for the court later on. If this case goes sideways at trial, David can't come back and claim he didn't know what he was doing or that the court forced him into this position. And notice how carefully the judge explains that advisory counsel is not representation. No cross-examination, no objections handled for him, no saving him from procedural mistakes. That responsibility lands squarely on David's shoulders. Sovereign citizen defendants often believe self-representation gives them power. In reality, it strips away safeguards. This exchange isn't dramatic, but it's dangerous for the defendant, because every yes locks him deeper into consequences he clearly doesn't fully grasp.
I appreciate that interest, but I can't. And let me explain to you why, very briefly. The law and the constitutions for both the state and the United States direct that each side, and that's important, each side has the right to a trial with a jury of 12 impartial persons. And I'm really just sitting here. I don't know anything about the case other than what I see on the charge sheet, which just tells me what there's 2 charges of failing to pay child support.
Correct.
If you all can't negotiate that between you, I don't really get involved other than monitoring the cases and making sure I know when I've got to be here and what's going to trial. I don't get involved. And even now that we have a trial by jury, I'm not involved other than I'm telling that I run Tiger Stadium here. I mean, this courtroom, and this stadium will be available for the 2 parties. That's it. Okay. So I appreciate that might be your interest and that might be an objective. I can't make a ruling unless there was an appropriate motion. Now, in a criminal case, you can't file a motion to dismiss. I'm always surprised by how many attorneys, not these 2 gentlemen, would file a motion to dismiss in a criminal case. You can't do it. You can in a civil suit. That would be different. But here we can't do that. The law does not allow me to resolve this case unless you were all doing a trial without a jury. Since you're doing a trial with a jury, all I'm in charge of is monitoring Tiger Stadium. Okay.
Could you please repeat yourself the last 2 sentences, because I heard something in there. I want to make sure I heard it correctly.
Hopefully I got it right. You can't do a motion to dismiss. Well, you can in the middle of the trial when the prosecutor rests. If the prosecutor doesn't prove each element, then you can do a motion for a directed verdict pursuant to Michigan Court Rule 6.429. Either 429 or 419. I think it's 429. You can do a motion for a directed verdict at that time. Until we get there, I can't dismiss a charge. There's some other rules, like if he violates the 180-day speedy trial clock, right, and you're sitting in trial in jail. But other than that, there aren't any ways that I can dismiss the case unless this case is before me. There's no jury and it's in a trial. So if you requested and waived your right to a trial, by the way, Mr. Denhouten would have to waive his right to a trial, and I would have to agree. Since you both have told me you want a jury trial, or at the very least, Mr. Denhouten has, I can't decide the case. Okay, that's all.
That's what.
That's okay. It's all right. That's what I'm here for.
I do appreciate you bring up the Constitution, because the arrest regarding when I was arrested.
Here's where courtroom reality starts colliding with fantasy. When the judge explains the logistics of a jury trial, the subpoenas, juror notices, time off work, and scheduling burdens, this isn't filler. This is the system reminding everyone involved that a jury trial is a massive legal undertaking, not a philosophical debate forum. And for a self-represented defendant, it's a minefield. Jurors don't care about YouTube legal theories. They care about evidence, credibility, and whether the prosecution proves each element of the offense. David seems focused on jurisdiction and abstract law conflicts, but the judge is focused on something much more concrete: procedure. Once a jury is impaneled, the court's role narrows dramatically. That's why the judge keeps repeating that he doesn't decide facts in a jury trial, the jury does. This is the exact moment where many sovereign citizen defendants lose leverage without realizing it, because the stage shifts from legal arguments to proof.
It's okay.
Their client.
An arrest warrant can be issued ex parte. The law allows that. There are rules that allow a district court judge or magistrate to issue an arrest warrant based upon a complaint.
Under the rules, but where does it say that in the Constitution? Because I've done read that puppy backwards, forwards, upside down, sideways.
It doesn't. It just says where a warrant, it just says an arrest without a warrant is illegal. But the Michigan law doesn't, Michigan law tells us what we can do, or what, not we, but law enforcement can do, because they don't work for me. I don't work for them. They have issued a warrant.
Right.
And they did it according to the rules.
Yes.
Yes.
And Marbury versus Madison, any law that Congress or any legislature passes, if it violates the Constitution, it's null and void on its face. I'm not here to argue. I'm just
that's okay.
Making you aware of what's happened.
It's been a long time since I had that class, which was common law, where we had to deal with Marbury versus Madison. I'm aware of it, but as of right now, there's nothing to address. So bond continues. We'll see you on the 19th, sir. Thank you.
And here it is, the familiar sovereign citizen pivot. The moment David starts talking about conflicts in the law, equity, and exclusive constitutional venues, he's stepping completely outside criminal procedure. These arguments sound sophisticated, but they have zero legal force in this context. Equity doesn't erase criminal liability. It doesn't cancel child support obligations. And it certainly doesn't override a jury demand. What makes this exchange especially telling is the judge's response. He doesn't mock David. He doesn't argue theory. He simply explains jurisdiction, rights of both parties, and the limits of judicial authority. That's devastating to these arguments, because sovereign rhetoric depends on courts reacting emotionally or defensively. Instead, the judge calmly explains that unless there's a non-jury trial or a procedural violation, he can't dismiss anything. This is where viewers should notice the gap between confidence and competence. David sounds sure of himself, but certainty doesn't equal correctness.
We're on the record today, 28 Circuit Court here in Missaukee County. Our first case this morning is People versus David Thompson. This is file number 25-1379-FH. Mr. Thompson, you can come and take a seat. I don't know which attorney's handling it. So
We are David Denhout on behalf of the people.
court recognizes the defendant, Mr. David Glenn Thompson, who is now at the defense table, and he is currently representing himself in this file. Mr. Thompson, as you might recall, I just need to go over a few things. The law requires me every time. Do you understand that you have the right to hire your own attorney?
That is correct.
And you understand that you have the right to have the court appoint an attorney to assist you if you cannot otherwise afford it?
That is correct.
And you also have the right to self-represent pursuant to the Constitution. You understand?
That is correct.
And you are electing to represent yourself. Is that correct, sir?
I am, Your Honor. Yes.
And I think you've represented yourself in this file the entire time.
Yes.
And through district court. Okay. All right. So we're here today for two things. The first is we're here today for a pretrial conference. The pretrial hearing today is just to find out where the case is going. The case is probably, yes, just recently bound over to the circuit court after going through the preliminary exam phase in the district court. And I see that the felony information was filed on February 6th. And the court then subsequently issued, assume I did. Yes, a scheduling order. Or about, actually, that was done on February 5th. Oh, it looks like the information was dated February 5th, but filed on the 6th. We're here again today for a pretrial conference hearing. Mr. Thompson, the only thing we do at a pretrial conference hearing is just to find out where the case is going. If there is a resolution of any kind, you guys can tell me. If not, then I'm going to ask if there are some other, I'm going to ask a couple other questions. The first thing here is see that the defendant is pending charges, and I didn't say what they were. Looks like there are 2 counts for a possession of a controlled substance. All right, Mr. Thompson, is there any resolution between this case, I'm sorry, in this case, as far as you know?
Your Honor, I believe there is.
Okay, well, hold on. I just got to ask the other party first, because a resolution means an agreement. Mr. Denhoughton, are you aware of any pretrial agreement?
I'm aware of that.
All right, thank you. That just lets me know that I've checked off that blank. What do you think is the nature of the resolution then?
Your Honor, I made a deposit with an ex parte hearing regarding another matter, equity taking jurisdiction to avoid a multiplicity of suits, putting up consideration for full accord and satisfaction and settlement and closure. To my knowledge, from what I understand, it includes all matters and all liabilities related. Now, I did realize that I should have directed the clerk to deposit that in accordance with the Judicature Act revised in 1961, Act 236, under section 600.576, depositing funds, stocks, or securities with the court clerk pursuant to court order is discharged from further liability. And in that matter, I was the payer, so I did that. And I'm still trying to make sure all of this gets settled and closure in honor.
This is one of the most important legal explanations in the entire hearing, and it flies over a lot of defendants' heads. The judge is absolutely correct. You cannot just file a motion to dismiss a criminal case because you disagree with it. Criminal cases move forward unless very specific legal thresholds are met. The judge even explains the correct time to raise a directed verdict, after the prosecution rests and only if they fail to prove an element of the charge. That's not opinion. That's black-letter law. What's striking here is that David asks the judge to repeat himself, not to understand better, but because he's listening for loopholes. And there aren't any. This moment exposes the danger of relying on internet legal advice. Knowing case names without knowing procedure is useless. And the court isn't here to coach the defense, it's here to ensure fairness. David is being warned in plain language whether he realizes it or not.
Oh, okay.
That would be another one of those envelopes that you.
Yeah. I understand. Okay.
If there's any other instructions or
You have
my duty that I'm aware of, but I'm willing to correct my mistakes.
Okay. Let's take a quick look here. And you were giving me a reference to the Judicature Act, and I know it's 600, and you referenced the
576, Your Honor.
Okay. And how do you think deposit? What did specifically again? Did you deposit
A certificate of security?
Okay. And so, what security was it that you tendered?
That was consideration
Or
any outstanding liabilities, Your Honor.
okay. So your deposit of this certificate of security applies to how much was it for?
That it has been unassessed and unknown at this time, which is what I'm seeking further from the court assistance in.
All right. So, and you think that somehow takes care of this particular file?
Due to the fact that where there's a conflict and variation in the law between common law and equity, Your Honor, equity shall prevail, and equity takes multiple jurisdiction to avoid a multiplicity of suits.
All right. So, are you charged with the possession of controlled substances in more than one case?
No, Your Honor, that case, I was a payer, which falls into this with the 600-576. And to my knowledge, a trust running in the background deserves to be heard in equity.
So in this particular file, there isn't, you don't owe anything.
My knowledge, I do not. I have,
No, so then.
my knowledge, I'm free and clear of liability, Your Honor.
No, liability is a different word. Liability doesn't apply here yet. Right? There's no judgment that says you owe anybody money. So there's no liability.
Thank you for correcting me.
Yeah.
This exchange perfectly captures a common constitutional misunderstanding. David believes that because the Constitution doesn't explicitly spell out every procedural detail, those procedures must be invalid. That's not how constitutional law works. The Constitution sets broad protections, while statutes and court rules fill in the details. Arrest warrants being issued ex parte is not unusual, it's standard practice. The key protection isn't prior notice, it's judicial review based on probable cause. The judge even references how warrants are issued under Michigan law, and David responds with case names instead of addressing procedure. This isn't a debate the court needs to win, it's already settled law. And notice how the judge ends it: bond continues, trial date stands. No drama, no escalation. Just reality. Sovereign arguments don't derail cases, they delay the inevitable.
Now, the question here is there a resolution to the case? Filing whatever you think you filed doesn't resolve this particular case.
I understand, Your Honor.
Okay.
In equity, I thought that they took jurisdiction to avoid multiplicity of suits. So
No. Multiplicity is something different. Multiplicity is generally used if you've been charged with the same act more than once, or if you've been tried more than once, then that becomes double jeopardy. Multiplicity is something entirely different, unless you're telling me you've been convicted of the same offense already before, which I know the answer is no.
I have not.
It's okay. So, I'm sorry, sir, I cut you off.
I do have evidence that I did deposit with the prosecutor's office a potential resolution.
Okay, so you made an offer to the prosecutor to resolve the case?
Yes, Your Honor, and I've got the
Okay.